Hello, it's Phillip Taylor speaking from Richmond Green Chambers in London. Today I'm looking at a book which has come to us from Jordan Publishing in Bristol. It's in their series of excellent books to assist us in the disciplinary and regulatory area. This book is now in an 8th edition. It's got a new editor and new people involved in it. The title of the book is Disciplinary and Regulatory Proceedings, very important area for all of us. It's now in an 8th edition under new people. It's been edited by Gregory, Treverton-Jones, Queen's Counsel, who many of you will know, Alison, Queen's Counsel, and Saima, Hanif, and they all come from 39 Essex Chambers. It's an excellent book. Brian Harris has now retired and gone to pastures new with Rudyard Kipling. So we've now got Gregory, Alison and Saima giving us a really excellent new edition with a perhaps new approach as they've overhauled where we are in 2015 concerning disciplinary and regulatory matters. Now, my wife Elizabeth and I had a long discussion about this book, and we've given it for our review this title: For a Regulatory Lawyer, the Definitive Work of Reference on Regulation, now in a new 8th edition. Let's have a look at the book first of all. It's a nice blue cover. There we go, you see that. Then there's the side, then the back. Now if we open it up, you can see at the back of the book we've got the index, and it's done in terms of paragraph numbering, which we'll get onto, so it makes it a bit easier for you to find things quickly. There's the beginning of the index there. Then we've got a number of different parts. For instance, I'm working backwards, so part 4 deals with data protection. You can see how it's structured. Chapter 17, you've got the paragraph numbering, which is at the sides, and you do have footnoting, which is therefore very helpful to find things quite quickly. What we've also got right at the front is the actual front page there. You've also got contributors, and there are a lot of people who've been involved in this. I can't mention all of them by name, but there are quite a large number. And then there's a very important preface which sets out what Brian Harris was doing and where they've gone since that time. Then you've got the contents page itself, quite detailed chapter headings all the way through disciplinary tribunals, civil liability and so on, the decision to prosecute, disclosure, confidentiality, the hearing itself, tribunal decisions, and of course things such as specific regulatory regimes, that's part 3, and then you're going on from there, the regulation of legal services, and then right at the end you've got the data protection side and freedom of information. Then you have a table of cases, some fairly well-known cases appearing there. Then you have after that some statute law. Then after that you've got the statutory instruments. And then after that we get some European material. That's now becoming much more frequent. Then we start off with a general statement on the jurisdiction of regulations. It's an important book and one that I think will be of great assistance, certainly to younger people coming up into the profession. I'm obviously fairly old and have come to this seeing the growth of regulation and disciplinary proceedings increasing quite substantially, and I'm sure that's going to continue. We are living in a world now which is very much dominated by regulation of what we can and can't do. You can talk about human rights, you can talk about all sorts of things, but the bottom line is there's a lot of regulation there. And that means you've got to know what you're doing, what you can do, what your responsibilities are, and what you mustn't do. And that really is why this book is quite helpful. It does, I think, in the detail of the book, and it is very detailed, it does give you some idea of where we're going at the moment. Obviously there are many people who think we're far too over-regulated, and there are a lot of other people who feel that this is having a little bit of an effect on free speech. It's kind of having a big effect on the way we actually conduct ourselves. And to some people it's considered to be a quite substantial erosion of rights at the end of the day. All of these issues are highly controversial. Many people will say it's rubbish, not correct, then other people will deny it. So it depends on where you sit. But however, I think the book is of great value and importance, and I'm very grateful to Brian Harris for what he did over the years and the reviews we've written in the past about his work in this area, and we welcome Gregory, Treverton-Jones and his team now. This is what we say about the book. Led by, as I said, a trio of top practitioners of regulatory and disciplinary law, the all-barrister team at 39 Essex Chambers, all 19 of them, have collectively assumed the mantle of the original creators as this definitive and highly regarded work of reference, and I think it is important to know where we're going. Since 1995, the book has now gone through 8 editions, of which this is actually the latest. So 20 years, I'm recording this 2015, the middle of the year. You can see there's been a lot of change taking place. It's been published by Jordan's, and it's well-established work now, which has undergone a major rewrite engineered by the expert authors and their team of contributors. The most important change, as far as we can discern, is that the book now focuses on the needs of the practitioners, which means that a large number of cases has been included that did not appear in previous editions. So that's perhaps a slight change from Brian Harris's era. The general principles that govern this area of law and their application are discussed in great detail, and I thank them for that. And there is an in-depth guidance on relevant procedures. Now, the 3 authors who I've mentioned, that's Gregory, Treverton-Jones, Queen's Counsel, Alison Foster, Queen's Counsel, both obviously senior barristers, and Saima, Hanif, are acknowledged experts in what is a dynamic and expanding area. As I said before, to some people it's quite unacceptable, but the fact of the matter is that is what is happening, and we have to recognise and make sure we know what we've got to do. So these 3 writers, together with their team, have aimed to create an essential tool in the armoury of those who practice in this law, a tool which is both useful and user-friendly. And that I certainly find and would concur is the case. The book is divided into 4 parts: general, disciplinary process, specific regulatory regimes, and data protection and freedom of information. Again, an important area right at the back. Interestingly, it is the general section at the front which will, I think, be of special and specific interest to the general reader, as well as perhaps the seasoned practitioner, because it sets the scene as to where we are at the moment. In discussing the jurisdiction of regulators, powers, principles and approach, which is the title they use, it does answer more than a few questions about regulatory powers, specifically statutory and contractual powers, and who exactly regulates the regulators. And that, of course, is the $64 billion question. Who guards the guards? Who regulates the regulators? Whatever it is, the question is always there. Someone's got to do it. Now, there's a quote from Mr. Justice Stanley Burton as an example, who mentions that, quote, "A statutory body such as the tribunal has only such powers as Parliament has conferred on it." And that's an important point to bear in mind. So, for instance, in the notorious case in the mid-1960s involving the Jockey Club's refusal to grant a training licence to a woman, the court held that the decision might be void has been contrary to public policy on discrimination grounds. To some, possibly a surprising point in 2015. Just shows you how far we've come and how quickly. Such is the clarity, then, with which these and any number of other areas are explained, because one of the problems I've tried to identify here for you is that regulation has very much changed with the climate of public opinion and where we're going. We have a different type of workforce, many more women, for instance, in the workforce than were before, and you can see attitudes have changed, certainly concerning both discrimination on the basis of gender and so forth, and rightly too as we move ahead. The question, of course, is always how far should you go and who's going to cover and who is going to have the fail-safe mechanism, if you like, when it comes to looking at what the regulators themselves get up to. And of course we all know that eventually the courts have to make some decisions. Certainly the book covers a range of subject matter which is too diverse to be detailed in this short review, but it does encompass virtually everything the practitioner needs to know pertaining to this area of law, including new chapters on disclosure and confidentiality and on the regulation of healthcare, financial services and legal services, all of which we may be thinking of seeing further changes take place in this new Parliament from 2015 to 2020. It's a full term with a Conservative majority government, so we may well be seeing some changes, probably subject in part to whether we remain part of the EU or not. I suspect that won't be quite as dramatic as some might think, but I think it's worth bearing in mind because quite a lot of stuff that's come through has been, to some people, perceived to have come as a result of our membership of the European Union. I don't necessarily subscribe to that view myself, but I think you've got to be aware that these are people's views. Those, therefore, doing further research, I think, will appreciate the book's ease of use, as well as the voluminous table of cases, statutes, statutory instruments and European materials. About 40 pages in total, just covering that area. Let me conclude by saying that with its radical restructuring, I'm sure Brian will agree, I hope he does anyway, and wealth of new material, the new edition of this book looms impressively as an authoritative source of guidance to practitioners and other interested parties involved in matters relating to tribunals, professional discipline and regulation, which is something we've got to face whether we like it or not. An essential tool in the armoury of the practitioner, it is indeed, and those words, the essential tool in the armoury of the practitioner, very useful choice of words, I think, especially within its legal, political and economic landscape, where regulation is becoming more common rather than less so. All regulatory lawyers should have a copy, and the publication date is cited at February 2015. Just a very quick look at it again. There it is, nice light blue cover, spine, nothing on the back. Just opening it up in the middle. This is pre-trial issues, this is for hearings and trials and various other things. It's become quite a substantial area. It's a growth area for people doing this sort of work, and for many people who've made comments to me. It's not the easiest area of work for a lot of people to be involved in. I think the regulation of the legal services area is very important for all of us, the SRA and so forth. And at the front, as I've said, you've got a very useful content section to go with the chapter headings, and then at the back you've got, again, a very detailed index. I'm very pleased with this book. I think it's a great value to everybody as we enter a new era. I'm at the end of my professional life, effectively, in terms of looking at what is going to happen, but it's this area that's going to grow, I'm quite sure, as we mature and as we see where we're going, because I've said with other reviews that we've written, we are in a global community now, and the regulations we have in this country are actually going to be reflected elsewhere. So we really do want to keep, I would suggest, in step with everybody else. Although I would say one thing, and that is we don't want to be overburdened with it. And I think a lot of people feel that we may be going a little bit too far, perhaps too quickly. But that's only a thought. And in the meantime, thank you, Jordans. We can't do without these books from you. They really are first class, so thank you so much. And thank you for the huge amount of work which all the people have put in to take on what Brian started off producing. It's a big task, and you've done it admirably. Thank you. Bye-bye.